Supreme Court of India. So, unlike the American Constitution, Indian Constitution established integrated judicial system. Supreme Court, that is top, and the High Court in below. Under a High Court, there is a hierarchy of subordinate court, that is district courts. The single system of the adopted Government of India Act 1935 enforces both central law as well as the state law. USA, on the other hand, federal courts are enforced by the federal judiciary and laws are enforced by the state judiciary. There is double system in the USA, one for center and the other for state. To sum up, federal country like USA has a unified judiciary and one system of fundamental justice. The Supreme Court of India was inaugurated on 28 January 1950. It succeeded the federal court established under the Government of India Act. However, the jurisdiction of the Supreme Court is greater than that of procedural because the Supreme Court has the place by Privy Council. Article 124 to 147 of Part 5 of the Constitution. Independent judiciary procedures and so on. Supreme Court, the Parliament also regulates organization. At present, the Supreme Court consists of the 31 judges. Now it is also 34, I think. Center notified an increase in the number of Supreme Court judges from the 26 to 31. Now it's 34, including Chief Justice of India. This followed the enactment of system of Supreme Court. Originally, the strength was fixed 8. The Parliament has increased the number of the judges, possibly 10, 13 and 17. Appointment. The judges of the Supreme Court appointed the President. The Chief Justice is appointed by the President after consultation such judges and High Courts deemed necessary. The other judges are appointed by the President after consultation with the Chief Justice of the High Court, Supreme Court and High Court as deemed necessary. And this consultation with the Chief Justice is obligatory in case of the appointments of the judges. Controversy. The Supreme Court has given different interpretation of the word consultation. Judges case of the 1982. The court held that the consultation does not mean the concurrence and it has the implied exchange of view, but the second judge case the court reversed ruling and changed the meaning. It ruled that the advice tendered by the Chief Justice of India is binding in the matter of the appointment of judges, but the Chief Justice would tender his advice on the matter after consulting two judges. Similarly, third judge case the court opined that the consultation process to be adopted Chief Justice of India required consultation, plurality of judges, and the sole opinion of the Chief Justice of India does not constitute the consultation. He should consult collegium for the senior-most judges collegium process, and that was senior-most judges of the Supreme Court, and even if two judges given an adverse opinion, he should not send the recommendation. The court held that the recommendation made by the Chief Justice of India without complying with the norms 99 Constitution Amendment Act 2014 and the National Judicial Appointment Commission replaced the collegium system and with a new body, that is National Judicial Appointment Commission. Supreme Court has declared 99 Constitution Amendment NJIC as unconstitutional and void. So there is a court opined that new system NJIC would affect the independence of the judiciary. Appointment of Chief Justice, that was in 1950 to 1973. The practice has been appointed the senior-most judges of Supreme Court as the Chief Justice of India. This established convention was violated. A.N. Ray was appointed Chief Justice of India by the suspending three most judges. Again, M.U. Beg was appointed as the Chief Justice of India by suspending the 10 most judges. This government was curtailed by the Supreme Court second judge case. Qualification: he should be a citizen of India and he should have a judge of High Court. He should have been advocate of the High Court for the 10 years. He should be a distinguished jurist. So these are the qualification. Oath and affirmation: a person appointed as the judges of the Supreme Court before entering upon the office has to make the subscribe on the oath and affirmation or some person appointed to him to be a true faith and allegiance, to uphold the sovereignty integrity, to duly faithfully discharge his duties, and to uphold the constitution and law. Tenure: he hold the office attain age of 65 years, and he can resign office by writing the president, and he can remove from the office by the president of the recommendation of the parliament. Removal: a judge of the Supreme Court can be removed by office order of the president, and president can issue the removal only after they address the parliament. So this is the whole process of the Supreme Court judge. The removal of motion. So he will be removed as a proven misbehavior and incapacity. The Judges Inquiry Act regulate the procedure. The removal motion signed the 100 member, then 50 member of the case is to be given the speaker. After then the speaker may admit to the motion to refuse. If it is admitted, then the speaker is to constitute a 3-member committee. The committee would consist of the Chief Justice of the Supreme Court as a Chief Justice of High Court. If the committee finds that judges guilty and misbehave suffering from the incapacity, after the motion passed by each of the House of Parliament and address presented to the President, finally President passes a order removing the judges. It is interesting to know the judges our Supreme Court has been impeached so far. The first and only case of impeachment was the Ramaswamy case, and now next is salary and allowances. The salary, allowances and privileges are the Supreme Court can be determined by the Parliament. They cannot be varied, and disadvantage will be there. Now next one is they also paid the sumptuarial allowances facility of the magical entitled 50% drawn from salary. Acting Chief Justice: the office of Chief Justice of India is the vacant. The Chief Justice of India is temporarily absent, or the Chief Justice of India is unable to perform its duty. In that kind, acting Chief Justice will work. Ad hoc judge: lack of quorum of the permanent judges to hold the continuance session of the Supreme Court. The Chief Justice of India can appoint a judge of the High Court as an ad hoc judge for a temporary period. He can do so only after consultation with the Chief Justice of High Court concerned and with the previous consent of President. The judge so appointed should be qualified for appointment as a judge of Supreme Court, and it is duty of the judges so appointed to attend the sitting of the Supreme Court in priority to other duties. While so attending, he enjoy all the jurisdiction and powers discharged by the Supreme Court. Retired judge: at any time, the Chief Justice of India can request a retired judge for Supreme Court, a retired judge of High Court, who is duly qualified for the appointments of judge of Supreme Court, to act as a judge of Supreme Court for the temporary period. He can do so only with the previous consent of the President, and also person to appointed such judge is entitled to his allowances determined by the President. He will also enjoy all the jurisdiction, power, privileges as a judge of Supreme Court. So this is the retired judge of the Supreme Court. The seat of the Supreme Court. So Constitution declared Delhi as the seat of the Supreme Court, but it also authorized the Chief Justice of India to appoint other place or place seat of Supreme Court. He can take decision in the regard only approval of President. This provision is only option and not compulsory. This means that no court can give direction either to President or Chief Justice to appoint any person as a seat. Procedure: the Supreme Court can, with the approval of the President, make rules for the practice and procedure and the constituent cases of the reference made the President. Article 143 are decided by the bench consisting of 5 judges. All other cases usually decided by the 3 judges. Independence of Supreme Court. Supreme Court has been assigned a very significant role in democratic political system. It is federal court and highest court, guarantor of the fundamental rights, and therefore independence becomes very essential. It should be free from the encroachment, pressure, and the interference of executive and legislature. Constitution has made the following provision for the safeguarding: mode of appointment. The judges of the Supreme Court are appointed by the President. Consultation with the member of judiciary itself, the provision is curtail the absolute discretion of executive as well as the judicial appointment. Security, the judges of Supreme Court are provided security of tenure. They are removed from the President only in the manner of ground of mention in the Constitution. This means that they do not hold that during the pleasure of President through the appointed. Fixed service condition, the salary and allowances of the leaves Supreme Court determined by time to time Parliament. They cannot be changed to their emergency, and the condition of services of judges determined by them. Expenses, the salary and expenses are charged by the administration. Supreme Court are charged on the Consolidated Fund of India. Conduct, the Constitution prohibits the discussion of the Parliament. State legislation with respect to the conduct of the judges discharge their duty, and impeachment is under the consideration of Parliament. Ban on practice after retirement. The judges of Supreme Court are prohibited from the pleading acting in any court. This ensures they not favor any hope of the future favor. And ban of the practice and power to punish contempt. The Supreme Court can punish any person for the contempt. Its actions or decisions are cannot be criticized. Freedom to appoint the staff. The Chief Justice of India can appoint the officer and servants of the court without interference from the executive. Its jurisdiction cannot be curtailed. The Parliament is not authorized to curtail the jurisdiction of the court. Constitution has guaranteed the Supreme Court jurisdiction various kind. Separation from executive. Constitution directs state to take steps separate judiciary and executive. Jurisdiction of the power of Supreme Court. Original writ jurisdiction, appellate jurisdiction, court of report, power of judicial review. So the final court of appeal, and also final interpreter guardian of the Constitution. It is advisory, supervisory power. Therefore, the Alladi Krishna, member of the drafting committee, remarks Supreme Court of India has a more power. Original jurisdiction, the Supreme Court has dispute between the different of the units. Sentence the state on the sides one more between the two states. In the above federal dispute, the Supreme Court exclusive original jurisdiction. Exclusive means no other court can decide such dispute, and the power to bear such dispute in the first. With regard to exclusive original jurisdiction, Supreme Court 2 points should be noted. The dispute must involve the question on which the existence of the legal right depends, thus the question of the political nature to any suits brought before the Supreme Court by the private citizen. So a dispute arising out constant treaty agreement, a dispute arising out the treaty agreement specially provided said jurisdiction does not extend. Matter referred the Finance Commission, adjustment of certain expenses, ordinary disputes of commercial nature, recovery of the damage. So 1961, the first suit original jurisdiction was both West Bengal. The state government challenged the constitution validity passed by the Parliament. With jurisdiction, Constitution has Constitution Supreme Court guarantor, defender of the fundamental right. Supreme Court is the empowered to issue the writ, habeas corpus, prohibition, quo warranto, certiorari for the enforcement of fundamental right. He disregards Supreme Court has original jurisdiction. Agreed person directly go to the Supreme Court. However, the writ jurisdiction of Supreme Court is not exclusive. The High Court also empowered to issue the writs. It means when the fundamental right of citizen violated, the agreed party can appoint moving the High Court. Therefore, the original jurisdiction of Supreme Court with regard to the federal disputes, and in this first it is exclusive and second concurrent. Moreover, the party involved the first case. There is also a difference between the writ jurisdiction of Supreme Court. Supreme Court can issue writ only for the enforcement of fundamental right, not other purpose, and the High Court on the other hand issue writ not only for the enforcement of fundamental right but other purpose. And it means the writ jurisdiction of the High Court is wider, but the Parliament can confer this. Appellate, the mentioned earlier Supreme Court has not only succeeded Federal Court but also replace the privy pairs. The Supreme Court is primarily court of the appeal. It enjoys wide appellate jurisdiction, appeal for the constant matter, civil matter, criminal matter, and the special leave. Constant matter: in the constant cases, the appeal matter Supreme Court judges and High Court certified involve the substantial law based on the certificate party and the Supreme Court. Civil matter case involve the substantial question of the general importance need for decided, and civil cases involved that could be appealed before the Supreme Court 20,000. Criminal matter has appeal reversed an order of the acquitted person sentenced him death has taken before itself any case from any subordinate courts sentence him death and certified that the case is fit on the appeal to Supreme Court. In the first two cases, the appeal lies to the Supreme Court, but if the High Court has reversed the order of conviction, so there is no right to appeal in Supreme Court. 1917 Parliament has enlarged the criminal appellate. According appeal lies the Supreme Court from the has a appeal reversed order acquitted and sentenced him to the imprisonment of the life and 10 years. So that is also in that. Has take before itself case from any subordinate court convicted accused for sentence life imprisonment or the 10 year. Appeal for special leave, it is discretionary power, hence cannot be claimed, and it can be granted judgment whether final. It may relate it to the constitutional, civil or criminal matter. It can be granted against any court and tribunal. The scope provision is very wide on the exercise of the power. Supreme Court itself held the being an exceptional power. Special extraordinary situation. Advisory jurisdiction, Article 147, on a question of the law and the fact public importance, on the dispute arising of the pre-constituent treaty and agreement. Supreme Court tender to refuse to the opinion. Now there is a 213. The President has made 15 references of Supreme Court advisory jurisdiction. Supreme Court is only advisory, not the jurisdiction pronouncement. It is not binding on the President. Okay. Now the Court of Record. The judgment proceeding and the act of Supreme Court recorded by the memory and testimony that these records are admitted for the evidentiary values and they cannot be questioned when they produced. They are recognizing legal precedents and legal references. It has power to punish the contempt of the court, and that was simple imprisonment, 6 months, 2000 will be the charged. Supreme Court has ruled that it has power to punish for the contempt not only itself but High Court, subordinate court and tribunals. Contempt of court may be civil or criminal, and judgment, order, writ, other process of the court are willful breach undertaking. Scandalize or lower authority, prejudice, interference with the due course of judicial proceeding. Power of judicial review. Judicial review is power of the Supreme Court examine the constitutionality of the legislative enactment, executive order, both the central and the state. On the examination, if they are found violative of constitution, illegal, unconstitutional and invalid, so they cannot be enforced government. Other power, decide the dispute regarding the election of the president. In this regard, it is original authority. It inquire into the conduct of the behavior of the chairman of the member of the Public Service Commission. Reference made. If it is found the guilty, it can recommend the president their removal. It has the power to review the judgment, order, and not bound by the previous decision. And brief, Supreme Court has a self-correcting agency. It authorized to withdraw the cases pending before High Court and dispose them itself. It can also transfer the cases for pending High Court. The law is binding on the court. Its decree or order is enforceable. It is ultimate interpreter of the Constitution and final version of the spirit of the content of provision. It has power to judicial superintendence and control over all courts and tribunals. Supreme Court senior advocate. They are advocates who are designed to senior advocates or High Court. The court is designed advocate with the consent as a senior advocate if upon virtue of his ability, bar special knowledge or experience in law of the advocate. A senior advocate is not entitled, but without the advocate of the court, Supreme Court, without a junior other court, he is also not entitled to accept the instruction to draw affidavit, advice, and all that. So there is some important points for Supreme Court. Its original jurisdiction confined to the federal cases. Its appellate jurisdiction was the civil and criminal. It has a very wide discretion, special leave to appeal matter against judgments. It has advisory jurisdiction. Scope of judicial review is limited. It defends rights of citizen according to the procedure established by the law. Its jurisdiction and power can be enlarged by Parliament. It has power to jurisdiction, superintend, control High Court due to integrated judicial system. And American Supreme Court, that is original jurisdiction, cover not only federal but also other cases. The appellate jurisdiction is confined to constitution only. It has no such plenary power. It has advisory jurisdiction. Scope judicial review is very wide, and it defends rights of citizen according to due process of law. So America, there is a due process of law. Its jurisdiction and power are limited to the conferred constitution. It has no such power due double judicial system. Now next one is Article 124 establishing the Constitutional Supreme Court, and 124A National Judicial Appointment Commission. 124B is function of commission. 124C power of parliament. 125 salary. 126 appointments of judges. 120 appointment of ad hoc judges. 128 advantage of the judges. 130 states Supreme Court. 131 original jurisdiction of Supreme Court. 131 exclusive jurisdiction of this regard. 134 appellate jurisdiction of the Supreme Court. 133 appellate jurisdiction Supreme Court appeal in the High Court. 134 appellate jurisdiction Supreme Court regarding criminal cases. And 134A certificate to appear to the Supreme Court. (135) Jurisdiction power of the Federal Court under the existence of the Supreme Court. 136 special leave to the appeal to the Supreme Court. 137 review the judgment. In the 137 he can review the judgment. 138 enlargement of the jurisdiction. 139 conferment of Supreme Court power for the writs. 139A transfer of the cases. 140 ancillary power. 141 law declared by the Supreme Court to be binding. 142 enforcement of the decrees. 143 power of the consult to the Supreme Court. 144 civil and the jurisdiction of this power. 144A special provision disposal of the cases. 145 rule of court. 146 officer and servants expenses. 147 is the interpretation.